So great, I think we're going to go ahead and get started. So thank you all so much for coming to our panel discussion today on the current Supreme Court. I'm Marin Levy, and on behalf of myself and Professor Ernest Young, my co-director of Duke Law School's program in public law, we are delighted to welcome you here today. So as you may have heard, a new justice recently joined the Supreme Court. Now, of course, there is always a heightened level of interest in the court when one justice retires and another takes his or her place. There are important questions that arise, which legal academics and commentators then try to address. Right? So namely, how will replacing one justice for another affect the court? And in particular, how will this shift affect the dynamic of the 9 Supreme Court justices? How will it affect the dynamic of the justices and the lawyers who appear before them? Will we see certain kinds of arguments being advanced more so than before? And perhaps most importantly, how will the addition of the new justice and the loss of the retired justice affect the development of particular areas of law? So again, by way of context, these questions always arise when the membership of the court changes, including most recently back in 2017 when Justice Neil Gorsuch joined the court. But I think it's fair to say that there has been particular interest in our current Supreme Court, largely because of the justice who stepped down. So again, I expect all of you know this. Justice Anthony Kennedy retired this summer after 30 years on the Supreme Court. And for a significant part of his tenure, he occupied what we might think of as the center of that court. And certainly, once Justice Sandra Day O'Connor left the bench back in 2006, Justice Kennedy was considered the swing justice. That is, the pivotal 5th vote needed to create a majority. So now, with Justice Kennedy having stepped down and Justice Brett Kavanaugh occupying his former seat, the questions that we mentioned at the outset are all still very much alive. How do we expect the court to change now that we have a new justice? And then additionally, how do we expect the court to change given that Chief Justice John Roberts now seems to occupy the court center? So to provide insight and even some answers to these important questions, we are joined today by a fantastic panel of distinguished Duke Law School professors, all former Supreme Court clerks. So from left to right, we are joined by Professor Kurt Bradley, who teaches and writes about foreign relations law, federal courts, and international law. Next, we have Professor Stephen Sachs, who teaches and writes in civil procedure, constitutional law, and conflicts of law. Next to him, we have Professor Ernest Young, who writes in constitutional law, federal courts, and foreign relations law. And finally, we have Professor and Senior Associate Dean Margaret Lemos, who teaches and writes about constitutional law, legal institutions, legislation, and civil procedure. So our panel members will each offer their own thoughts on how the court might shift given its new composition. I will then have a question or two for the panel before opening it up to questions from all of you. Professor Bradley, will you start us off?
Thank you, Marin, and thanks to everyone for coming to our discussion. Before giving a few of my observations about what's our current Supreme Court, I thought I might give a couple of thoughts about perspective now that we're a little bit past what were obviously very fraught appointments, hearings on the Kavanaugh appointment. So a couple of perspective thoughts. One is it has been about 30 years since I graduated from law school. Time really does fly, it seems like. And it was right after Kennedy had been appointed to the Supreme Court. And so I looked to see how many appointments there had been since I got out of law school. And there have been 10, including Gorsuch and Kavanaugh. And exactly 5 turned out to be liberal, and predicting Gorsuch and Kavanaugh in the conservative column, exactly 5 will have turned out to be conservative. So it's a suggestion that at least in the long term, these 10 things may tend to balance out, although it may not seem like that at any particular time. And the second kind of point of perspective is I was getting ready for this panel, and I was reading an article by Professor Cass Sunstein, and he expresses concern that, quote, the Supreme Court has finally taken a sharply conservative turn, and he predicts various cutbacks in progressive rights, the overturning of Roe against Wade, and a likely disallowance of affirmative action and many other changes. And that article was published in 1990. So again, these debates are not entirely new, and the concerns are not entirely new that you'll hear about. Having said all of that, my own prediction is, just to say the obvious point first, is we will have a more conservative Supreme Court, at least in the next few years, with the replacement of Kennedy with Kavanaugh. And it turns out, I think, to be interestingly difficult to define exactly what we mean when we say conservative and liberal in this context. I think we have intuitions about it, but it turns out to be complex. But I guess what I mean here is one can expect a court that is less sympathetic than it had been to rights favored by political liberals, sexual orientation rights, abortion rights, and the like, and more sympathetic on average to rights favored by political conservatives, gun rights, property rights, and the like. Probably more sympathetic overall to federalism and states' rights as well, although I think one can at least argue that the conservative justices are not entirely consistent about that sort of a commitment. We can talk about that as well. We know a lot about the judicial ideology of both Kavanaugh, who's just come onto the court, and Roberts, who is likely to be kind of the median justice now. Roberts has been on the court quite a while and was on the D.C. Circuit before, and Kavanaugh has been on the D.C. Circuit, I think, for about a dozen years. And so we have lots of opinions to know their views in the context of those opinions. And it's not like some prior situations. When I clerked at the Supreme Court, Justice Souter joined the court that year, and he really didn't have a lot of federal court experience, and I think surprised a lot of people with how liberal he became. But I think we can expect fewer surprises out of these particular justices, given that we know a lot about their views. But having said that, my main point to get us started is I think predicting what the court's likely to do runs into a number of complications that we should at least be thinking about. One is Chief Justice Roberts has already, as Chief Justice, I think, shown an internalization of his role as the Chief Justice in various ways, including just last week going back against President Trump's tweets, concerns about judicial independence and legitimacy. Cases like the Affordable Care Act cases where he ends up surprising people and joining the liberal justices. One can imagine that he might internalize an additional role as kind of a median or center justice as well. And that might affect either how he decides the outcome of cases or at least the way in which he pushes how they should be written. And I think one can look back at median justices, O'Connor, Kennedy, and see some ways in which they probably internalized that particular role as well. So how might that take shape? I could imagine Roberts pushing even more than he usually does for adherence to precedent, constitutional avoidance, avoiding constitutional questions when possible, and writing decisions in kind of a minimalist fashion rather than reaching as far as they could possibly go. And I think he's already shown inclinations in that direction. We might see more of it. Even for issues, though, on which Kavanaugh will clearly, almost certainly be more conservative than Kennedy was, we have to keep in mind that Kennedy was not exactly an across-the-board liberal justice by any measure, and there'll be lots of issues in which Kavanaugh's views, at least in terms of the outcome, will probably be similar to Kennedy's. It will make a difference only where they likely would have diverged, and probably only in close cases where they would have diverged, maybe a 5-4 case where we could look back and see Kennedy was in the majority and Roberts was in dissent. We might find that Roberts and Kavanaugh might make a new majority. But that won't be routine. I looked, and the figures are for the last, well, more than 15 years, the number of 5-4 decisions by the court is under 20%. We just forget about that because we often tend to focus on the closely divided ones. And in many of those, it won't be the case that Kennedy and Roberts were dramatically at odds, for example. And so the number of possibilities may be low. Another important factor, of course, I mentioned it already, is stare decisis, respect for precedent. So even in cases where we can see Kennedy was in the majority, Roberts was in dissent in the 5-4 case, it is not necessarily true that a new majority will just overturn the precedent. So just to take an example, the Obergefell decision was 5-4, the gay marriage decision, with Kennedy in the majority, Roberts in the dissent. I could imagine Kavanaugh, if he had been on the court at the time, might have joined Roberts. But I could also imagine the court not overturning Obergefell, even if in some sense they have the votes. It's a reasonably well accepted decision. There's been a tremendous amount of reliance on the decision. And in other contexts, we don't see changes in composition on the court automatically overruling all the precedents they wouldn't have voted for in the first instance. A couple final thoughts, really tying into something I said at the beginning. We do need to be wary of the labels conservative and liberal, I think. They can sometimes obscure really quite important differences among justices within a coalition. So just to take one area that I tend to focus on in my courses, which is a deference to executive authority and executive power. Sometimes that's described as more of a conservative position, but here's one difference you might see among the justices, which is some justices who are very deferential to the president are that way only if there's not a statute directly on point. That is, in the absence of Congress intervening, they tend to defer to the president, but maybe much less deferential if Congress regulates. And Kavanaugh in the D.C. Circuit has shown some tendencies in that direction to defer to Congress when that happens, maybe in some instances more than even Kennedy would have. And I can give examples maybe when we have questions. And then finally, just another possible wild card here is Justice Gorsuch, I think fairly described as a conservative justice, replaced Scalia, but is also kind of libertarian, anti-regulatory, and sometimes that leads in what we would call liberal directions. He did vote with the liberal justices in a couple of close cases last term, including in an immigration case where he had concerns about the vagueness of the relevant statute, and justices who are concerned about undue delegations of authority, for example, similarly sometimes will come out in what we would regard as a liberal direction as a result of that preference. So my bottom line is, yes, I think it's fair to say we will see a more conservative court for the next few years, but I think what that means in practicalities is complicated and probably difficult to predict. Thanks.
Thank you. Professor Sachs.
Thank you. I think, again, to echo Professor Bradley's comments, it will be a more conservative court. But the things I'd like to talk about are somewhat follow-on consequences. So, for instance, it is a matter of math now that if you want to win your case at the Supreme Court, you need a vote from either the Chief or Justice Thomas or Justice Alito or Justice Gorsuch or Justice Kavanaugh. You have to have one of those five if you're going to win your case. And that's going to lead to a number of changes in the way that cases are lawyered, and that itself will have follow-on consequences for the law. So you can imagine litigants who go in thinking that this will be an uphill battle for them, needing to make a particular originalist argument, let's say, to attract the attention of Justice Thomas or Justice Gorsuch or any of the other justices, perhaps Justice Kavanaugh as well, that they would not necessarily have made if that were not the five vote, that group of five were not a group that they needed one of their votes from. You can imagine the textualist arguments will become more common. Recently, in an immigration case, attorney Cecilia Wong made a very effective, though it may not in the end have persuaded, argument about the adverbial phrase in the statute that Justice Gorsuch appreciated a great deal because it took the text very seriously in a manner that he is known to do. And so you can imagine those kinds of arguments becoming more popular as a result of the shift in the court's composition. I think if you do the Google Trends study 5 years from now for the number of references to dignity in Supreme Court briefs, you're going to see a nosedive that will be roughly around June 30th of 2018. And the reason for that is not that it was some sort of magic spell to get the attention of Justice Kennedy, but that the lawyers thought that it might. And so the lawyers thought, well, we know Justice Kennedy writes about dignity, so let's put a lot of references to dignity in the brief, and maybe he'll like us. Those kinds of considerations really do affect the way that cases are lawyered, and they also affect the way that lower court opinions are written. The lower court cares not only, if it seeks to avoid reversal, cares not only about the content of the legal rule, but also the kinds of arguments it's making for a legal rule. It's much easier to reverse, that crazy lower court decision if the kinds of arguments advanced in its favor are arguments that no longer carry quite so much water with the 5-justice majority. You can imagine litigants seeking a minimalist approach to attract the attention of the Chief Justice, or a more functional approach for Justice Alito. And these are vast oversimplifications. I think it would be wrong to describe the Chief as a minimalist, quote unquote, or Justice Alito as a functionalist, end of story. But these are sort of tendencies and aspects of tone in different opinions that lawyers will pick up on and will seek. And that has effects not only for how you guys learn to write briefs, but also for how lower court judges structure their opinions and how the law more generally is carried out. A second change that I think Professor Bradley also noted is that there are differences within this conservative majority. I don't think it's necessarily the case that the Chief Justice will become the new swing justice instead of stepping into Justice Kennedy's shoes, in part because it's not clear that's a role that he necessarily seeks, but also because it's not clear that there will be only a single swing justice. As we've seen with Justice Thomas, Justice Gorsuch, often you have strange lineups even in 5-4 cases. And it is entirely possible that there will be a number of swing justices on different axes for different reasons than the standard conservative-liberal split that we saw with Justice Kennedy in the middle. There are also reasons that go to the sort of internal court politics. So it's sometimes easier to write a 6-3 narrow opinion than it is to be in the middle of a 4-1-4 and to sort of have an opinion that no one else agrees with. And to be deciding on grounds that no one else quite takes. So it might well be that you will see more 5-4 opinions and fewer 6-3 opinions of various kinds because of the lineup of the new majority. Another way in which people in the new majority might differ is not in the sense of what their first best preference is, but whether they really want to clean up old opinions, whether cleaning up old doctrine is seen as a positive advantage or whether it's better to let sleeping dogs lie. This is something on which different justices take different views. I think it's safe to say that Justice Thomas puts a greater priority on avoiding repeating old errors, as he might see it, than some of the other justices do. Some of the other justices are more willing to say, if we don't have to extend a body of incorrect precedent, even if we think it was incorrect, we can just let it lie. I think there are definitely a number of opinions like Obergefell, but also much less high-profile cases. So whether an independent redistricting commission qualifies as the legislature of the state for purposes of the Elections Clause, whether recess appointments are constitutional in which circumstances. These are things on which there were 5-4 decisions, in which the new court would probably come out differently than the old court had, but it's not at all clear that they are immediately going to dredge up all of the decisions and vote the other way, but they might be forced to it. So it could well be that a case comes up that can't easily be distinguished. If you look at the Chief Justice's opinion, his concurrence in the Citizens United case, one of the approaches of the defenders of the statute was to try and identify a number of intermediate grounds on which one could preserve the prior precedent, but the Chief Justice's concurrence essentially said those grounds don't convince any of you, so why should they be convincing to me? And so if you can't find a ground that actually suffices to avoid reconsideration of an old precedent, the court might well be forced to it. So even if they're not looking to dredge up old cases, even if they're not looking to change what the existing body of precedent is, they might find themselves in a position where they have very little choice. On that score, how much can we learn from Justice Kavanaugh's time on an appellate court? I think actually a relatively large amount. When you're on an appellate court, you're constrained by Supreme Court precedent as well as the precedent of your own court. You can't do everything. But I think it's fair to say that Justice Kavanaugh, when he was Judge Kavanaugh, seemed to swing for the fences in a number of cases, especially in cases involving separation of powers questions. There were cases like the Free Enterprise Fund case, cases like the appointment of administrative law judges, where I think just Judge Kavanaugh, as a judge, was willing to write relatively broad opinions on formalist grounds that other judges might not have been or might not have seen as necessary to make the point. So if that's a correct analysis, I think as a justice, it's quite plausible that now Justice Kavanaugh would seek to write relatively broad opinions in areas where the question is squarely presented and squarely before the court. And in general, I think the stock price of formalism and separation of powers has probably gone up since last year.
Thank you, Professor Sachs. Professor Young.
So I don't see why legal academics are so down on President Trump, because every week he gives us something good to talk about. Last week, the president got enjoined by a federal court again, this time with respect to restrictions on asylum requests on the Mexican border. The president responded by tweeting that the district judge was an Obama judge and criticizing the Ninth Circuit, which has affirmed injunctions against a lot of Trump programs, as a big thorn in our side and a disgrace. So somewhat surprisingly, Chief Justice Roberts actually responded to the president, telling an AP reporter that we do not have Obama judges or Trump judges, Bush judges or Clinton judges. What we have is an extraordinary group of dedicated judges doing their level best to do equal right to those appearing before them. Then finally, just to make the occasion more festive, the Democratic Senate leader, Charles Schumer, weighed in to say that he was thankful that Roberts had stood up to President Trump and for an independent judiciary. But he said that only after ripping the Chief Justice, in the same tweet no less, for his partisan decisions which seem highly political on Citizens United, Janus, and Shelby. So I guess you could consider Senator Schumer as taking an intermediate position between the president and the chief. There are no Obama judges, but there are definitely Trump and Bush judges. And I raised this episode because I think it's fair to paraphrase the question addressed by this panel as, what difference will it make to have a bunch of Trump judges on the Supreme Court? And someone inclined to take the Roberts view might be inclined to resist the very notion of that question. There are no Trump judges. I take it the chief would likewise say there are no Republican judges or Democrat judges and no conservative judges or liberal judges. There are only judges doing their jobs with dedication and professionalism. I haven't done a survey, but my impression is that most everybody in the legal academy and the legal profession had the same reaction I did to this whole episode, which is basically, yay, chief. You might say it's his finest moment since he opened his opinion in Stern versus Marshall with an extended paraphrase of Bleak House. And I think it gives some insight into the role he is planning to play on the newly constituted Supreme Court, which is the guardian and advocate of the court's institutional legitimacy. As I said, yay, chief. But here's the thing. I don't think that anybody actually agrees with the chief. Senator Schumer certainly doesn't. He attacked Roberts in the very same tweet as being a partisan judge, and he led the assault on Brett Kavanaugh because he thought Kavanaugh would be a Trump judge. Most journalists writing about the court think it's important to note the partisan affiliations of the justices and expect that those affiliations drive decisions much of the time. So do many political scientists writing about judging, and all legal academics who are influenced by the legal realist and critical traditions, which is most of us. We wouldn't be having this panel if we didn't think it was significant that the court now has a solid majority made up of conservative Republican appointees. If you're here, chances are it's because you agree with President Trump that the ideological bent of a justice matters a great deal in driving the results that the justice is likely to reach. So we might take our instinctive agreement with the chief as more of a reflection on what it's appropriate to say publicly than of disagreement with Trump's basic view of judging. And of course, sticking to what it's appropriate to say publicly isn't this president's strong suit. Those norms may be eroding more generally. Multiple prominent Democrats, including Senators Feinstein and Blumenthal, have explicitly questioned the Supreme Court's legitimacy in the wake of the Kavanaugh appointment. There have been open calls for court packing. But I think it's fair to question why we would have a norm that requires us to pretend that judges aren't political if, in fact, we're convinced that they are. And I think the main reason to be careful about what we say is that when we say that judging is political, important nuances are likely to get lost. And the key nuance for me is that simply because many legal principles have political content and correlate strongly to partisan affiliation, that doesn't mean they aren't legal in nature or that deciding cases under them isn't decision according to law. So the scope of national power, or the extent of unenumerated rights, or the extent of executive power, or the meaning of constitutional equality, these are all highly political issues. But they're also legal questions about the meaning of legal texts and precedents. So law and politics are not antonyms, and we shouldn't treat them as such. These are also questions about which reasonable lawyers can differ. Just as reasonable people disagree about the right moral or political answer. Reasonable lawyers differ about the legal answer. And from a legal perspective, how you answer these questions is often interconnected. That is, people who believe in limited national power or limited presidential power are likely to also be somewhat skeptical about unenumerated rights. And these have to do with connections between the questions that are either methodological or substantive. So as a result, lawyers, judges, academics, we tend to have at least a somewhat coherent legal worldview on constitutional questions, especially. And those legal worldviews correlate pretty strongly to partisan political ideology. Not perfectly, but pretty strongly. So Democratic judges are more likely to believe in expansive national power and unenumerated rights than Republican appointees. That doesn't mean that partisan politics is driving those beliefs. It may in some cases be the reverse. It does mean that partisan affiliation is a pretty good predictor of what judges are likely to do in closely contested constitutional cases. So there's good news and there's bad news. The bad news is there are Trump judges and Obama judges. It's meaningful to talk about judges' partisan affiliations as a good clue toward their legal worldviews. The good news is that I do believe judges make decisions based on the law, even if partisan affiliation helps us predict what those decisions will be with reasonable accuracy. So even if we aren't surprised an Obama judge enjoined the president, and won't be surprised when the Trump-Bush Republican Supreme Court overrules that Obama judge, the president is wrong to say that the decision-making process is a disgrace. So let me add one last point that I think is something of a saving grace, and that is a lot of the legal principles identified with Trump judges are methodological or structural. So Trump judges tend to be originalist methodologically. They tend to be very interested in structural principles like federalism and separation of powers. The stock is going up. These interests correlate to party, but the principles are themselves legal principles, and they will not infrequently push in unpredictable ways in individual cases if they are applied neutrally. So originalism can press in favor of certain liberal positions, an expansive establishment clause, for instance, or limitations on presidential war powers. And federalism can shield secessionist hotbeds of the resistance like California. So the court's sports gambling case, for instance, Murphy versus NCAA, is likely to shield both sanctuary cities and states trying to legalize marijuana. That's a result that Trump judges are likely to applaud. So I would expect this court to remain consistent on such things, regardless of the politics of individual cases.
Thank you, Professor Young. Professor Lemos.
Hi, everyone. I don't think I have a lot of new concepts to add to this, but I want to throw out two distinctions that I think might be helpful for thinking through these issues. The first has to do with terminology. And so in our conversation so far, and in lots of conversations about these kinds of things, we hear two different terms that don't always mean the same thing. One is median justice, and the other is swing justice. So there's, as you would imagine, a pretty large literature on these topics. And in that literature, those terms typically mean importantly different things. So the median justice is just simply the justice who's at the center of the court. So if we're able to line up all the justices along some dimension, and I'll say more about that in a second, the median justice is simply the one who's the fifth out of 9. And that could be at the middle, or it could be way over to one side or another, right? It's just the median. Swing justice often is used to mean something different and more specific, and something that doesn't always exist. And so that is a justice who's between two roughly equal blocks of justices and who swings between them with some frequency. Some people say it's got to be even close to 50% in order to count as a swing justice. So I think we can be quite sure that Justice Roberts is the median justice on the court now if we're looking across all issue areas and aggregating. And pretty certainly he's not going to be a swing justice in the way that Justice Kennedy was on some issues. It may be that the current court just doesn't have a swing justice. So then that gets us to questions of measurement. everything I've said so far suggests that we can figure out how to line up the justices along some, some dimension. In other words, that we could construct what a social scientist would call a spatial model to line them up. And most studies of this sort that are looking at things like the median justice or the swing justice use only one dimension. And so they're assuming that the justices' votes can pretty well be described or explained or predicted by one thing. And they assume that that one thing is ideology. But that, of course, begs the question of how we figure out what the justices' ideologies are. And for these purposes, we can't use the crude measure of Republican or Democrat based on party of the appointing president, because as others have discussed, that just gives us two choices, right? It doesn't allow us to line up 9 people in different ways. And the whole thrust of this conversation is that we think there might be meaningful differences between these two Republicans, Justice Kennedy and Justice Kavanaugh. And so instead, what studies that are looking to line justices up spatially do is base that alignment on their votes. And so they look at who's voting with whom in lots of different cases. And doing that allows them to say, okay, we see Breyer and Kagan pretty close to each other, and they're kind of in the same neighborhood as Ginsburg, but they're closer to Kennedy than Ginsburg is, and so we can line them up in that order. But that's really important to keep in mind that that's all they're doing, because it doesn't actually tell us anything about what is behind those votes. It could be ideology, but it could be something else. And so, when we see a pretty good correlation between the sort of crude party of the appointing president measure and a lot of a justice's votes, we can be pretty sure that ideology is playing some role, although that might be, as Professor Young said, because there's a great deal of overlap between sort of policy and law in the kinds of questions that the Supreme Court deals with. But we don't know. And the studies that try to situate the justices don't purport to prove what it is that's driving those alignments. They just refer to preferences. And so the idea is we can be pretty sure that justices are voting the way they want to vote. But it leaves completely open what kinds of preferences those might be. So take that back to the median justice. We know that Justice Kennedy was in the middle of the court on many issues. But we don't entirely know why. It could be that he was just a pretty moderate conservative, so he was sort of center of the road politically. But it could also be because other considerations weighed heavily for him, at least in some areas. So some folks think that Justice Kennedy cared a great deal about public opinion, for example, in some areas. And so that could just be that other considerations are pushing him toward the middle in those kinds of votes. The same is true for Roberts. And so as Professor Bradley mentioned, there's reason to think that Justice Roberts' role as Chief Justice has already been affecting his votes, and that might be drawing in considerations that weigh more heavily for him than they would otherwise. And there may be reason to think that his newfound role as median justice, at least on some issues, might serve that same purpose. We just don't know yet. Now, the last thing I want to emphasize on this point echoes something that Professor Sachs also noted, and that is it's important to distinguish between who's the median generally. So if we're aggregating all cases, and so if we're looking like who's the median over the course of a particular term, that's going to be Justice Roberts. That was Justice Kennedy before. But if we break things up by subject area, for example, and look at how justices' votes align in different kinds of areas, it turns out everybody's the median some of the time. Kennedy was the median on a lot of issues. And now we don't know who's going to be the median on all of those issues. But as others have emphasized, we do see very different alignments in different issue areas. And that complicates any kind of discussion about who is the median. Okay, so that gets me to this second distinction that I want to draw just quickly, and that's between opinions and outcomes. Professor Bradley mentioned this, but I think it's really important in thinking through how the court might be different with Justice Kavanaugh as opposed to Justice Kennedy. So on many issues, Justice Kennedy was a pretty reliable conservative vote. And in those areas, we are unlikely to get different outcomes now than we would have gotten before. But we may get really different opinions because the majority coalition is now made up of different people. And in particular, Roberts, or whoever it is, the role of whoever is the pivotal voter or the median voter on that issue may be particularly important in shaping the content of the majority opinion. Now, we as lawyers know that in many cases, what matters most is not necessarily who wins or who loses, that's outcomes, but what the rule is that the court lays down. And lots of people who have studied this think that the justice who's in the median of that particular case holds the key to the rule, because that justice can often mount a pretty credible threat of either switching sides or more likely just peeling off from the majority coalition and depriving the court of an opinion of the court. And so there, differences between Kennedy and Roberts may matter to what our law ends up looking like, which we care about a great deal, even if the outcome is the same as it would have been before with Kennedy playing that role. That's it.
Great, thank you so much. And thank you all for those insights. So I just want to start us off with a question for the panel. So we've all touched here on a number of important points, including how certain methods of interpretation might now receive more support among the justices and how the lawyering before the court might change. And I'm just wondering, are there any particular areas of law that you think might shift given the new composition of the court?
I'll talk about one that probably won't, well, I do think it will shift, but not because of outcomes, so because of opinions. And this is related to something that Professor Sachs said. So you all probably know that the longstanding precedent that says that courts should defer to judgments of administrative agencies has come under increasing attack in most recent years. Justice Gorsuch was a vocal critic of Chevron on the Court of Appeals, and so his elevation to the Supreme Court seemed to make it more likely that the Supreme Court might make a move. And now all 5 members of the likely conservative majority have at least expressed pretty serious reservations about Chevron, and that includes Kennedy. So very shortly before he announced his retirement, Justice Kennedy surprised many people by writing a concurrence in which he said maybe it's time for us to reconsider this doctrine of deference. And so in that sense, his replacement with Kavanaugh might not make that big of a difference, and they both seem to be fairly anti-Chevron. But getting back to what Professor Sachs said about swinging for the fences, this is an issue where Kavanaugh has been particularly vocal and seems to have some deep commitments. It's kind of one of his things, and it's related to separation of powers in general being sort of his thing. And so my prediction is that exchanging Kavanaugh for Kennedy raises the likelihood of the court doing something exciting in that area. Who knows? Justice Alito is kind of a wild card here. He's expressed some reservations about Chevron, but hasn't been consistent on it. Ditto Roberts. And so it's hard to know exactly how it'll play out, but this seems like an issue that Kavanaugh wants to leave his mark on.
I'll throw out one example from an area that I teach in foreign relations law, which is the kind of general national security law area. In particular, we had a series of cases concerning the Guantanamo detention facility in the post 9/11 war on terrorism. And a lot of people were surprised the Supreme Court seemed more interventionist than had traditionally been true in prior, more traditional kinds of conflicts, including overseas military activities and the like. And one of the most noteworthy decisions in the late 2000s was Boumediene against Bush, when the Supreme Court, in a 5-4 decision written by Kennedy, decided that, in fact, the non-U.S. citizens being held at the Guantanamo facility all had a right to access to the federal courts to seek habeas corpus review. I think it's possible that was a shock to the Bush administration, which I think had housed the detainees there specifically with the thought that it would be outside of judicial scrutiny, since it's not in really technically U.S. soil. Closely divided case, and we have reasons to think that Kavanaugh was involved in very similar decisions, including those decisions on the D.C. Circuit, probably would have joined the dissenters if he had been on the court, and might well, therefore, have changed the outcome. Like many examples, though, it may not be one we'll see an exact replica of. That issue is decided, that there's habeas review. Those cases have all kind of gone through the courts now out of Guantanamo. Most of the detainees are not there anymore. So that specific precedent probably isn't in jeopardy. But if we have other kind of war on terror national security issues about how much to defer to the president, how much judicial review there ought to be, I think it's a reasonable prediction that it'll be lower than what Kennedy probably would have been comfortable in terms of judicial scrutiny. So that's one thought.
Great, thank you. Any other thoughts?
This is a somewhat smaller bore, but there may now be 5 votes to get rid of the Lemon test. This is a test for Establishment Clause violations and when the government is endorsing religion impermissibly under the Establishment Clause. There have been 5 votes to get rid of it for a long time, but nobody actually wanted to pull the trigger. And I think Scalia referred to it as the horror movie ghoul that kept crawling out and being sent back again. But, you know, maybe this court will actually do it. Other areas, I think, you know, as I said before, separation of powers, I think you're going to see a lot of appointments clause decisions under this court that you might not have seen under the previous court. And also areas we're not really thinking of. I mean, I don't think that anyone necessarily thought, you know, certainly upon the day that George W. Bush became president, no one thought like, oh, this will be an era that will be dedicated to national security issues. And things are going to surprise us and we will not know what they are. So it's a little hard to say. You know, you can always come in with a sense of how you want to change things, but you have no idea what kinds of cases are going to be presented to you when you get there.
So one follow-on to that point is that if the issue set changes from the issue set that the president was considering when he makes the appointments, the president's usually pretty good at predicting what the justices they pick are going to do on the issue set that is most salient to him at the time he decides. So when FDR picks, you know, Hugo Black, Felix Frankfurter, William O. Douglas, and Robert Jackson, he puts them on the Supreme Court to uphold the New Deal, and they all reliably do that. They vote like clockwork in all those cases. He was absolutely right about how they were going to vote. But then the issue set changes long after FDR is gone, and now it's questions of individual rights and equal protection and you know, free speech, things like that. And they split, and they go off in all kinds of crazy directions, right? Because that wasn't what anybody was thinking about when they put those people on the court. So that's one of the things that I think makes it hard for the president to control the court. On specific issues, I'll give you 2. So I taught Morrison versus Olson this morning, which was the independent counsel case. And I would not be at all surprised to see that go the other way if it comes back to the court. And I wouldn't be that surprised to see it come back to the court, particularly if this new bill in Congress to protect Robert Mueller passes. I think it'll be a tough case for the chief because there's going to be the perception that a court full of Trump judges is protecting President Trump. I think that'll be unfair because I think the conventional wisdom about, you know, whether Morrison versus Olson was right really changed in the 90s as a result of the Starr investigation. It won't be a result of the Mueller investigation, and as part of a general trend toward more formalism and separation of powers law, which I would expect to continue. The other thing is this court may be terrible for federalism. Kennedy was an enthusiastic proponent of the Rehnquist Court's federalism revolution. He wasn't really, you know, in some ways he was a median justice on those questions, but in some ways he was one of the most, you know, enthusiastic proponents. And I just don't see any reason to believe that Kavanaugh is going to be anywhere nearly as enthusiastic as Kennedy was about those issues, which is terrible.
Poor Professor Young. Well, thank you so much. So we wanted to leave quite a bit of time to have you all ask questions. So please, folks who have questions, let us know. Yes, and you should feel free to come down and use the microphones or just be quite loud. Up to you.
So to the extent that Justice Kennedy's, at least in more progressive circles, really people are thinking about Obergefell, the gay rights cases, Casey, to what extent is the fact that Kavanaugh clerked for Kennedy make him potentially more likely to not strike against the kind of popular legacy of his mentor?
Not at all. Yeah, I just don't see that as the constraint. There are lots of things that might make people hesitant to overrule or substantially limit Obergefell or Casey, but I don't think the clerkship relationship would be the operative one. I also don't see the court, I mean, I've given up all prognostication after the 2016 election in that sense. But I don't see this five-justice majority as being particularly eager to write the maximally broad opinion in those fields if a case comes up. That does not mean that I see one of those 5 votes for explicitly reaffirming Roe, nor do I necessarily see one of those 5 votes as explicitly reaffirming Casey. The question is how a case comes up to the court and whether it would be necessary to do one of those things in order to, in order to dispose of the case, in order to reach the judgment. If they have to say Roe was right in order to affirm, they're not going to say that, and they're not going to affirm.
Other thoughts? No?
I don't know. I mean, I think, the myth is that clerks brainwash their justices, but the reality is clearly that justices brainwash their clerks. I mean, the thought of Justice Souter's disapproval just would still reduce me to a quivering lump of flesh. So, maybe you just didn't love your justice the way we did. I think Kennedy's clerks loved him.
It is called tough love.
Great, there was another hand up. Yes.
Any or all of the panelists could speak to how there being a much more solid conservative majority on the court might affect the cases the court decides to take.
That's a tricky one. So, as you know, it only requires 4 votes to take a case. And so there's a sense in which losing Kennedy shouldn't make any difference. But there is a deeper sense in which when people vote on cert, they are trying to game out, likely, what the outcome will be. And so I think this is related in part to Professor Sachs' point about swinging of unpredictability with any new justice. And although we know a lot about Justice Kavanaugh's record on the DC Circuit, those are different jobs, and it remains to be seen what he's going to be like as a justice. And so, the first couple of years, the justices are likely to be feeling each other out and trying to get a sense of sort of how far everyone is willing to go and what their general style is. But then clues will emerge, and I think where we'll see differences are in issues that have been floating around for a while and that everyone knows are, sort of delicate and really, I agree with others that the likelihood is more in the chipping away. And the question is just, does it seem like we're ready now? Is now the time? When I was clerking, so I clerked for Justice Stevens, and we didn't participate in the cert pool, and so we saw every cert petition, and we had to do very minimal memos for him. But we had like a list of issues like that that were just, you're going to see these, and if you look at them with your naive new clerk's eyes, you'll think, oh my goodness, the court should grant cert in this. But we all know that we're just not doing that until something happens. And so I think there will be an interesting process in which the justices kind of figure out their readiness or willingness to take up certain issues, like the Chevron issue, for example, that have been out there for a while, and it's just a question of, is now the time, and then what's the right vehicle?
One thing that struck me about kind of the late Rehnquist court is they were willing to decide stuff, right? They decided big issues that I think other courts might well have avoided. So Boumediene's one example. One of the issues in Boumediene is, to what extent is there a constitutional limit on Congress's power to restrict the jurisdiction of the federal courts? And that's a question that's been kicking around for 200 years. and which the court had always avoided. There was only one decision that ever struck down of congressional statute limiting the jurisdiction of the federal courts, and that decision was so narrow and so strange that nobody had any idea what it meant. And so I quite confidently predicted that they're always going to avoid this question. They're just going to construe the statutes to allow some little window of judicial review and say we don't have to decide. Boumediene, they could have done that. They didn't. They reached out, and for the first time since Reconstruction, they struck down a limit like that. Obergefell, the court takes that very quickly after Windsor, right, and reaches out to decide that question. And I can't help but wonder if the reason why was just a development of a sense of confidence as a court. That court had served together for a very long time, and I think, people like Justice Kennedy especially had just developed a confidence and a comfort level that, this is the court that decides stuff. We're the decider. And we're not going to avoid these questions. The country needs an answer, and we're just going to give it to them. And so I wonder if, once you really shuffle the deck again, if it might take a while to redevelop that kind of confidence. Or maybe it was just a trait of Justice Kennedy's that we won't see again for a while.
Other thoughts? Great. How about some more questions? Yes, sir, in the yellow hat.
On the question of specific cases that we might see a shift in, do you think we're going to see a third good year for the non-delegation doctrine?
No.
Maybe.
No. I mean, so maybe, because that's one of the arguments behind the challenges to Chevron. But just where do you go with it? I mean, the court can't, with a straight face, say that Congress has to fix how it behaves with respect to agencies, but that it's totally fine for courts to do all that work. And so unless they just want to, shut down the federal government or have some kind of pipe dream about Congress completely changing the way it acts, that's the reason why they haven't done anything with the non-delegation doctrine for so many years. And so, they might be tempted, but I don't see them pulling the trigger on that.
The non-delegation doctrine has had a number of good years as a matter of statutory construction. Right? So you construe delegations narrowly. You construe delegations not to cover sensitive areas like the power to restrict individual rights. And so in that sense, it's alive and well, and I would expect it to expand. And the big thing pushing back against that tendency has been Chevron. And so the court has already been making inroads on Chevron based on these kinds of concerns about non-delegation at bottom, but I don't think they'll use the non-delegation doctrine itself. I think they will restrict the power of administrative agencies because they're worried about non-delegation, but it won't take that form.
And just even for a recent example, I think just argued the other day, the sex offender registration case, which delegates discretion to the Attorney General to decide on whether to designate as sex offenders people who committed their crimes prior to the statute, and seems in some ways to be an open-ended kind of granted discretion, seemed to trouble the justices about this kind of discretionary grant, but it looked like, from the argument at least, they were looking for a way just to construe the statute as not doing what you might think it's doing to avoid this very question. I think that'll be the temptation.
Great. So I think we have time for just a couple more questions. Yes, sir, in the back.
In the court of public opinion, of which I am a lifelong member, the current environment is one in which the Supreme Court is despised by a significant portion of the population, as is the present administration, as is the legislative branch to a certain extent, too. I would like your considered opinion as to what extent you think the individual personalities of the Supreme Court justices will be influenced by public opinion during the next 2 years, 6 years, and perhaps after that.
So I think this is one area in which there are many different publics, because the Supreme Court has been despised for a long time by a lot of folks. And so I think it will It will depend a lot on who sort of the justices see themselves as responding to. I think there was a sense that the chief had sort of bowed to popular pressure in the ACA case. I don't think that's right, and I don't think I'm saying that just as sort of, respect for former boss. I was surprised when I read the opinion, but I was surprised when I saw the bottom line of the opinion. But once I read it, I was like, oh yes, this is a very chiefy opinion. This is just the sort of opinion he would write. And so I'm not sure how much they react to, the New York Times editorial page in a way that they might have to a greater degree in a previous era, and whether that's in part because of changes in sort of the structure of public opinion, or whether that's just changes in who the justices are friends with and respond to, and whose disapproval they worry about. I think that the answer to that question is different now than perhaps it was 6 months ago.
Yeah, and there have been lots of academic writings, of course, about the connection between the Supreme Court's decisions and public opinion, however that's defined. Many, I think, finding that the court generally does not get too far out ahead of public opinion, and you can see many examples in which the court seems to be lurching towards certain things that might be societally controversial, but finds ways to kind of take its time to get there, or to signal steps along the way, just as a way of kind of modulating its role in our society in dealing with those decisions. So it certainly seems to be aware of the public environment in which it operates. I don't think it's a popularity question as much as a sense of the fact that the court is kind of the last word in a lot of important legal questions, and is one of the branches of government. I would say, from the national security law area, a lot of people thought it wasn't about popularity, but the court seemed to be aware of the conditions in which the United States found itself in the 2000s, with a kind of protracted, unexpectedly protracted, indefinite kind of conflict that didn't look traditional, people being detained without any kind of particular rights regime attached to it. And when the court first started intervening was about exactly the time, I think that day of the argument in a case called Hamdi, was on the news, was people from Abu Ghraib being, the photos of people on the box with the hood over their head. And it seemed to affect the justices' understanding of the legal questions in ways that I don't think were about popularity, but were about the sense that their decisions are obviously interacting with the rest of what's going on in the country.
One of the conundrums that the president presents for his opponents is whether to view him as a buffoon or an evil genius. And I can't help but wonder if, having solidified his Republican majority on the Supreme Court, but being worried about the court's legitimacy and popularity, he didn't choose to do the one thing that would rally most of his opponents to the Supreme Court's support, which is to attack the judiciary, right? And now, to the extent that the Supreme Court becomes perceived as, a valuable check on an unpopular president, then I think it's likely to broaden its support over the next few years.
Great, I think we have time for just one more question. Any last hands? Yes.
Back during the New Deal, as I understand it, the court stopped opposing the New Deal after the whole court packing scare. With in the current environment, with some Democrats talking about packing the court, do you expect the current conservative majority to sort of moderate itself in anticipation of that threat, or do you think they don't take it seriously?
I think they probably don't take it seriously, but I also think that's related to the last question about public support for the court. So we can think about public support for the court as an institution, which is typically called diffuse support. And then we can think about support for specific court decisions. I do think the justices, and maybe particularly the chief, care about public support for the court as an institution and their view of the court as a legitimate institution. One of the reasons why you might care about that is that if you really went wrong, you might end up running into things like court packing schemes. But my guess is that they're worried about things short of that, like before they get to court packing, and that the threat is a little bit too distant for that to be the thing that's pushing them.
I agree with that. Having looked into the 1937 debates on court packing, one of the things that I was surprised to find was that plan really ran into a lot of trouble before the Supreme Court kind of made its switch and started moving in a different direction. And so there may be a sense in which it's unrealistic because one hopes the political safeguards tend to kind of mobilize around such a big kind of threat to the institution. They may assume that to be the case. The other thing I'd say is if there is now a big discussion of court packing, not particularly based on what the Supreme Court's about to decide, but unhappiness about what's already happened with the Merrick Garland situation and others. And so to the extent there's a kind of momentum behind it, it may not be specifically about what the Supreme Court's going to be doing.
Terrific. Well, I think we are officially out of time. Please join me in thanking our wonderful panelists, and thank you all for coming.